Good morning. This is your Kelso Report for Tuesday, November 15th, and I'm your host, Clark Kelso. Well, the big news of the day is that the Supreme Court has granted review of the 11th Circuit's decision in Florida versus Department of Health and Human Services, where the 11th Circuit struck down the individual mandate provision of federal health care reform because it exceeded Congress's power under the Commerce Clause. The 11th Circuit also held that the individual mandate provision was severable from the remainder of the health care reform bill. Now, in granting review, the Supreme Court specifically directed the parties to brief and argue whether the suit brought by respondents to challenge the minimum coverage provision of the Patient Protection and Affordable Care Act is barred by the Tax Anti-Injunction Act. The Anti-Injunction Act here generally forbids, subject to specified exceptions, a federal court from enjoining the collection of any tax. The purpose of the Tax Anti-Injunction Act is to channel litigation challenging tax laws into the specific procedures enacted by Congress for individual taxpayers to complain about their own tax bill, and to avoid the interference with the administration of the tax laws, which would result if litigants could seek broad injunctions against the enforcement of tax laws. The issue is important here because one of the arguments in support of the healthcare law is that the individual mandate is actually a tax authorized by the Taxing and Spending Clause. But if it is a tax, then the challenge to the law is premature and should not be brought until the tax is actually imposed on an individual, which will not happen until 2014 under the Act. So it is at least possible the court could decide that it needs to defer resolving this case until 2014 at the earliest. Now, if the court gets by the Anti-Injunction Act, it then will decide whether the individual mandate provision exceeds Congress's Commerce Clause powers, and if so, whether that provision is severable. My guess is that Justice Kennedy will be the key swing vote here, and that his vote will depend upon whether he views the individual mandate as simply part of the ordinary regulation of the healthcare marketplace that all of us are already involved with one way or another, in which case he will apply existing Commerce Clause precedent and easily uphold the law, or, in the alternative, whether he will view the individual mandate as an unprecedented attempt by Congress to compel individuals to enter into a new congressionally created marketplace over their objection, in which case he will very likely vote against the law, concluding that Congress cannot create a national market of its own making and then compel everyone to participate in that market. We know that Justice Kennedy in the Commerce Clause area is capable of creative jurisprudence. So, that makes this case a real toss-up. Now, the court has set aside 5½ hours for argument of the issues, an extraordinary amount of time that signifies the importance and complexity of the issues being reviewed. Arguments will be scheduled for next March, and we will see a decision probably late in June, just before the court concludes its term. Our featured case today involves the proper interpretation and application of the California Supreme Court's decision in Stanson versus Mott, where the court held in 1976 that government entities generally may not use public funds to pay for campaign activities, but may use such funds to make available informational materials relating to an election. The Stanson decision has created a fine line between information activities and campaign activities. In today's case, Peninsula Guardians versus Peninsula Healthcare District, the first district held that a hospital district which distributed information pertaining to a ballot measure that authorized the construction of a new hospital managed to stay on the right side of the law. Now, trying to distinguish between campaign activities and information activities under Stanson can be quite a challenge. Some things are pretty obvious. Public funds may not be used to purchase such items as bumper stickers, posters, advertising floats, or television and radio spots. Public funds may not be used to distribute campaign literature prepared by private proponents or opponents of a ballot measure. On the other hand, a public agency acts properly when it provides a fair presentation of the facts in response to a citizen's request for information, or authorizes an agency employee to present the department's view of a ballot proposal at a meeting of a public or private organization upon that organization's request. These extremes leave a big gray area where it appears the agency may itself be pushing out information about a ballot measure, but it is still doing so in a relatively neutral way that tries to simply set forth objective facts without obvious campaigning. According to the applicable law, in these type of cases, the court must consider such factors as the style, tenor, and timing of the publication, and no hard and fast rule governs every case. In yesterday's case, the First District upheld the Hospital District's communications because the material was primarily factual and informative. It told the district's residents what would happen if the ballot measure passed and what would happen if the measure did not pass. The materials were presented in the district's regular newsletter in a style and format consistent with the newsletter's prior informational style, and the content avoided argumentative or inflammatory rhetoric and did not urge voters to vote in a particular manner or take other actions in support of or in opposition to the measure. The court's opinion, which includes copies of the newsletter materials, is a very helpful roadmap to all public agencies about what constitutes permissible informational activity in anticipation of a ballot measure. And now our one-liners for today. First, in Los Angeles County Metropolitan Transportation Authority versus Alameda Produce Market, the California Supreme Court unanimously held that if a lender holding a lien on condemned property applies to withdraw a portion of the quick-take eminent domain deposit filed by the public entity which is condemning the property, the lender's withdrawal constitutes a waiver of the lender's claims and defenses with respect to the property, and it does not constitute a waiver of the property owner's claims and defenses, which is what the Court of Appeal had held. In particular, the property owner retains whatever arguments it has that the public entity lacks proper legal authority to take the property. The court's holding really was compelled with the plain meaning of the applicable statute, section 1255.260 of the Code of Civil Procedure, which provides that if any portion of the money deposited pursuant to this chapter is withdrawn, the receipt of any such money shall constitute a waiver, by operation of law, of all claims and defenses in favor of the persons receiving such payment, except a claim for greater compensation. Well, the property owner doesn't receive the payment when the lender withdraws the money. Next, in People v. Nelson, the First District affirmed the defendant's conviction for violating Vehicle Code Section 23123, which states that persons shall not drive on public roadways using a wireless telephone unless the phone is configured for hands-free listening and talking, and used in that manner while driving. The defendant was observed using his phone in his car as he paused at a red traffic light. He argued he was not driving because his car was stopped during his phone use. Now, the First District rejected this argument, holding that the legislature intended the statute to apply to persons driving on our public roadways who may pause momentarily while doing so in order to comply with the rules of the road. Next, in Sharia versus County of Stanislaus, the Fifth District held that the Board of Supervisors of Stanislaus County violated the state's anti-NIMBY law, section 65589.5 of the Government Code, by voting to reject an application for a proposed residential development project without making written findings identifying specific adverse impacts upon the public health or safety that would result from the project. Instead, the board tried to fit its denial within an exception to the written findings requirement for projects that do not meet applicable objective general plan and zoning standards and criteria. But the only even arguable nonconformity was that the developer had requested an exception to a local requirement that all houses be connected to the public water system, a request which had been denied. The developer indicated that given the denial, he intended to connect all homes to the public water system. Yet the board still cited the development's non-compliance with the connection requirement as the reason for its overall denial of the project. Well, the Fifth District saw right through the board's pretextual denial and ordered the Superior Court to grant a writ of mandate vacating the board's denial and directing it to reconsider the application. Next, in the area of attorney's fees, in Sallay versus Surfside, The Second District held that the Defendant Condominium Owners Association was clearly the prevailing party and therefore entitled to attorney's fees when the plaintiff voluntarily dismissed without prejudice 8 of 10 claims only 3 days before trial was to begin. The Superior Court had denied the $252,000 in requested attorney's fees. The remaining 2 claims went to trial, which resulted in a defense judgment. Well, the Second District found no justification for denying attorney's fees to the Condominium Owners Association and reversed the denial of fees. And the court affirmed the defense judgment on the remaining 2 claims. Next, in a little area of water law, in Dabani v. Del Norte Water Company, the Second District held that the Articles of Incorporation and Bylaws of a water company, which prescribed the method of water allocation among its shareholders, was not subject to Section 400 of the Corporations Code, which sets forth certain allocation rules applicable during a water shortage, since the Articles and Bylaws predated enactment of Section 400, and the Act which added Section 400 contained statutory language exempting existing Articles and Bylaws from its application. According to the Second District, there was therefore no discriminatory treatment in water allocations under the Articles or Bylaws, which allocated water on the basis of the ratio of the number of shares in the corporation, the water corporation, to the number of acres owned. Next, we have a very interesting family law case in Rich v. Thatcher, where the Second District held that to overcome the presumption that a fit parent will act in the best interest of his or her child, a grandparent has the burden of proof in an action seeking visitation over the parent's objections, and must show by clear and convincing evidence that denial of visitation is not in the best interest of the grandchild. The court imposed the higher standard of proof because of the strong presumption that the custody, care, and nurture of a child reside first in his or her parents. On the facts, the Second District affirmed the Superior Court's conclusion that the grandmother did not satisfy her burden, because there was substantial evidence that the relationship between the grandmother and the child's mother was so strained and disruptive that denial of visitation would not be detrimental to the child. The Supreme Court also granted review in 2 other cases. First, they granted review in Commissioner of Social Security v. Caputo, which raises a fascinating issue of statutory interpretation. The claimant, a mother proceeding on behalf of her twin children, was claiming that the children should be able to receive children's benefits under the Social Security Act, even though they were conceived through artificial insemination after the death of her husband. So the question is whether the children who were posthumously conceived after the wage earner's death nevertheless qualify as children under the Social Security Act. That'll be an interesting one for the court. And lastly, the court also granted review in City of Indianapolis v. Armour to decide whether the Equal Protection Clause was violated when the city, as part of its transition from one method of assessing property owners for sewer fees to a newer method that overall imposes fewer burdens on property owners, discharged all outstanding assessments owing as of a particular date, but did not give refunds to those property owners who had previously paid their assessments in full or in part. The Indiana Supreme Court held that this disparate treatment did not violate equal protection because forgiving only the outstanding assessment balances was rationally related to a legitimate governmental interest. And that's it for today's Kelso Report. Have a great day in the law.